What's up, everybody? Thanks for tuning in to Channel 99 today. We've got with us an awesome group of people. They are here to discuss a little bit about Trump's executive order on the travel ban, a little bit of background on the law and whatnot. I honestly don't know much about that, so I'm going to leave that up to them. Make sure that you subscribe, give us 5 stars, pass the episode along, and have a wonderful rest of your day. Peace.
Shut up and sit down.
Welcome, everybody. This is Objection Asked and Answered, reading the Constitution so you don't have to. My name is Erica.
Do you think Islam is at war with the West?
I think Islam hates us. There's something there that there's a tremendous hatred there.
That was then candidate Trump speaking to Anderson Cooper on CNN in March of 2016. In January of 2017, President Trump issued Executive Order 13769, often referred to as the Muslim ban or the travel ban, that lowered the number of refugees to be admitted into the United States, suspended the U.S. refugee admissions program for 120 days, suspended entry of Syrian refugees indefinitely, and suspended entry of those from 7 different countries for 90 days. These countries, all of Muslim majority, were Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. When this travel ban went into effect, more than 700 travelers were detained and up to 60,000 visas were provisionally revoked. This led to widespread chaos for the travelers and for their families. After this order was signed, there was widespread condemnation and protests that led to legal intervention. A nationwide temporary restraining order was issued on February 3rd of 2017 and was upheld by the United States Court of Appeals for the Ninth Circuit. This led to President Trump signing a new executive order, number 13780, on March 6th of 2017 that would supersede the original travel ban. This new travel ban excluded Iraq from the list of banned countries. It gave travelers time to prepare so they would not be blindsided at the airports. The ban on Syrian refugees was modified, and existing visas were to remain valid. The new travel ban was also challenged in court. While the arguments were waiting to be heard by the Supreme Court, parts of the ban went into effect. People from the 6 banned countries without what the administration calls a bona fide reason to be here were not allowed in. As we dive into our program, we'll be addressing the legality of the travel ban and how it affects people both inside and outside of the United States. Joining me to discuss these issues is Jonathan Wheatley.
Hey.
Christy Brown.
Hi.
And Tony Lee.
Good morning.
Welcome to Asked and Answered. If our listeners have any questions or comments, please feel free to reach out. You can find us on Instagram at Objection13780. Check it out. It's real. So let's jump right in and start with Jonathan. This seems like a pretty bold move on President Trump's part. Talk to us a little bit about presidential powers. What even gives him the right to do this?
Yeah, so essentially Article 2 of the Constitution outlines the role of the executive branch, and this is where the president receives most of his power. These powers can be broken down into 3 different categories. There's foreign affairs, war powers, and then powers given in domestic authority. Because of the nature of the travel ban, most of the actions done by the president come from the foreign affairs and the domestic authorities power. When it comes to foreign affairs, the president's essentially the representative of the United States in everything that comes to foreign relations. Some of the president's authority may have been drawn underneath this section in relation to the travel ban. However, most of it came from the domestic power. The domestic authority given to him allows him to do a lot of different things. Some of these include appointing and removing federal officers, granting pardons. But for this topic, mainly we want to focus on executing federal laws. The Take Care Clause, found in Article 2, Section 3 of the USC, requires that the president enforce federal law. And under this clause, the president has the authority to create executive orders to do this. And he's generally given broad discretion as to how this is done. These orders allow the president to implement laws created by Congress. So in a way, he's not necessarily creating new laws, but he's coming up with ways to enforce the laws that have already been created. And this is where 8 U.S.C. 1182F comes into play. And essentially, that says that when the president finds that the entry of a certain class of alien into the U.S. would be detrimental to the U.S.'s interests, he has broad discretion to suspend entry into the United States. And this can be done for an indefinite amount of time. So to answer your question, that's essentially where he gets the power, is from that Article 2, Section 3, and then even further through that United States Code.
Thanks, Jonathan. I appreciate the background. Yep. Let's move on to Christy. So how have executive powers been used by former presidents, and what did the courts have to say about their constitutionality?
I'm going to briefly talk about two cases. The first case is Korematsu v. United States. During World War II, Japan had just bombed Pearl Harbor. We're at war. The government was concerned about espionage and sabotage. And so in that way, they issued Executive Order 9066, which singled out Japanese Americans, basically telling them that they have to relocate to these internment camps. And under that one executive order, there were a couple other smaller orders. One in particular was Civilian Exclusion Order number 34, which specifically excluded Japanese Americans from military areas such as San Leandro, California. That's where Korematsu lived. They said he had to leave. He didn't want to. So, it's in the courts. Gets all the way up to Supreme Court, and they're looking at whether the president has power to issue this type of executive order. They look to the Constitution, and they say, yeah, this is basically we're at war. This is justified because they can't figure out where their loyalties lie. And so they say they have to take them as a group, put them in these camps. So just real quick, some quick numbers just to give it some perspective. 77,000 American-born citizens of Japanese descent taken to these internment camps. 45,000 Japanese nationals who resided here permanently taken to these camps. Wow. And local history, 10,000 were interned at the Minidoka Internment Center in Jerome County, Idaho.
It's close to home.
Idaho.
A little bit closer.
A little bit, yeah, right? So to summarize it, constitutional war power, he was within his right to issue that executive order. Youngstown, Sheet and Tube Company v. Sawyer, president was not within his presidential power to issue this type of executive order, which was 10340. Basically, it was enacting a type of law. He wanted to take over the steel mills down in, it doesn't say exactly where, but in 1952, because they wanted to go on strike. And he was concerned about the reduction in the production of steel affecting war materials and war weapons. Mm-hmm. So Supreme Court took a look and said, no, Congress didn't give you this right. And, it's not expressly stated in Article 2. So no good, Mr. President. Unconstitutional.
Gotcha. So we have one that is constitutional and one that is not.
Yeah.
Alrighty. So let's move on to the current case, Trump v. Hawaii. So after President Trump's travel ban went into effect, the state of Hawaii challenged it in court. In September of 2016, the Supreme Court granted review. One of the questions put in front of the court was whether the president had the statutory authority to issue such a proclamation. The court held that the proclamation did not violate the president's statutory authority or the Establishment Clause. So Chief Justice John Roberts authored the opinion for the 5-4 majority. And under Statute 1182F of the INA, the president has broad discretion to suspend the entry of non-citizens into the United States. The proclamation was the result of a worldwide multi-agency review that determined entry by certain non-citizens would be detrimental to the interests of the U.S. Thus, the proclamation did not exceed any statutory authority of the president. So like in Korematsu, the proclamation by the president was challenged as pretext for what has been considered widely as discrimination against those who practice Islam. 1152A does bar discrimination based on the nationality and issuance of visas, but it does not limit the president's ability to block the entry of some nationals, just as several other presidents have done in the past. And subjectively, the way I read into this is that the courts have effectively and precedently ruled that 1182F of the INA says that the president has the authority to suspend the entry of anyone ever into the United States, and that's more important than 1152A that says that the president may not discriminate based upon nationality and other intrinsic variables. So let's go ahead and move on to Tony. He's going to tell us a little bit about what's going on and how it's affecting people now. So the majority-based part of this opinion on arguments offered by the Department of Justice, which claimed that a robust waiver process would allow citizens from the blacklisted countries to enter into the United States if they met certain criteria. The administration cited this as evidence that the travel ban was rooted in national security concerns and not in the discriminatory intent to ban people based on their religion. What is this waiver process? And tell us a little bit about how effective it's been.
Oh, that's a great question. Thank you. Chief Justice Roberts was convinced that the waiver process would provide humanitarian exceptions to the ban, and as such reasoned that the government's actions weren't discriminatory in nature. The waiver provision in the ban sets out that those barred from entry from the 7 listed countries can be granted waivers if they meet a 3-part test that was set out by the order. Prong 1, the denial would cause undue hardship. 2, entry would be in the national interest, and 3, entry would not pose a threat to the national security or public safety of the United States. Adding to the confusion, though, Section 3C of the order explicitly directs Secretaries of State and Homeland Security to clarify the process. However, there are no published instructions as to how or where individuals apply for these waivers. And what is being learned is that applicants' country of origin or where they're currently living is not considered when determining whether a denial would cause undue hardship per the first prong of the waiver granting test. The problem with this, is that the hardship of being in one of the blacklisted countries is the reason someone may be seeking the entry into the U.S. in the first place.
Yeah, that's super interesting. So how is someone supposed to get one of these waivers?
Right.
Awesome. So let's move on. Has there been any data released by the Department of Justice to show that the waiver process is an effective humanitarian exception to the ban, as Chief Justice Roberts had articulated?
Well, 1 month after the ban went into effect, the government released statistics showing that there had been 2 visa approvals out of 6,000 applicants.
Wow.
In April of 2018, the statistical frame shifted that the administration was using to, show this information, and instead, the number of individuals that were cleared for visas, which was 996 as of July of 2018. However, it's unclear as to how many of those 996 have actually received a visa to enter the United States. Due to uncertainty surrounding the waivers, there is actually a new lawsuit that was filed in the Northern District of California, Imami v. Nielsen. Now, the suit's not attempting to attack the ban itself, but simply requesting that the administration clarify how it's granting these waivers.
Right.
The lawsuit alleges that the process is arbitrary and capricious, in violation of the Administrative Procedure Act, and that it violates due process.
Interesting. So how has this affected refugee relocation in the United States?
Well, to be quite frank, it has been devastating. Section 5D of the order states that refugee entry shall be capped at 50,000 individuals in 2017, as any more than that would be, and I quote from the order itself, detrimental to the interests of the United States. However, that cap, while an incredible decrease from previous years, is largely overstated. In 2016, the U.S. admitted over 30,000 refugees from the 7 countries named in the ban, mostly from Iran, Somalia, and Syria. But as of May 31st, 2018, that number has plummeted to 330 individuals in total.
Wow.
I spoke with a friend of mine from the International Rescue Committee here in Boise, who had told me that refugees from the named countries in the ban, their relocation here to Idaho has mostly ceased, and that's evident as well across the United States. Wow. And now the bulk of their assistance here in Idaho has been to help recent Congolese arrivals, which are individuals from a Christian majority country.
Oh, wow.
Wow, that's really moving. I appreciate the insight on that. Travel ban has really obviously had a trickle-down effect that has had an impact in our own community.
Yeah.
Well, that's all the time we have for today. Thanks for joining us and tuning in to Objection Asked and Answered, taking requests for future constitutional issues on Instagram at Objection13780. Alrighty, guys, back to reading the Constitution. Don't worry, reread it for the articles.
Thank you.
Thanks.